clear intent of my lords that it will go back to the High Court and they will determine is a cry of anguish by the learned High Court judge. Just see 2 paras of that. What they have done, my lord, with both sides of the...
No, but that's absolutely wrong.
We can do away with the literature.
Allow me to finish.
Please allow me to finish.
ED as well as the special court PMLA said that using the provision of section 8 of PMLA, the attached assets of the promoters are to be disbursed to satisfy the claim of the home buyers, which I am one of the home buyers.
Mr. Sadhu, do you want to say something additional?
Yes, my lord. I want to say this, my lords. First, my lord, direction should be given to the learned judge in the High Court to decide the matter as soon as possible, preferably within a time-bound 1 week or so. One.
Lord, in 45, there are 3 IAs. 1 by us, we are the original petitioners, and 2 by people who are frustrating the High Court from hearing the matter. Just see the last order which the High Court has passed in our IA, my lord. The IA by GWA. If your lordship will see that IA,
Well, the IAM
the order is at
appearing in the
366.
relief, it can't be granted in this case.
No, no, no. My IA is also there.
On multiple occasions.
Just see that order which your which.
Still pending before Justice Bhagwani.
Yes.
yes.
The whole idea is to somehow ensure that he doesn't hear it.
If my lords may
Day after day, my lord, dates are being taken that we are going to Supreme Court. And Supreme Court is going to further clarify something, and that is why they are not permitting that hearing to go on. And they are repeatedly coming here only to frustrate that hearing. Only the whole purpose is to just see his last order, my lord.
I have one additional point I want to make, my lords. This is a blatant attempt to interfere with Justice Narasimha's proceeding, where he has reserved orders on an appeal as to whether the CIRP order, admission order, should be recalled on grounds of fraud. In order to get some observation from your lordships that they can then place there, they haven't filed written submissions as required within 1 week by his lordship's order, by his lordship Justice Narasimha's order. So, my lords, I represent a home buyer, my lords. There are 1,091 of us. My lord, the Chief Justice, has been very vehement about, my lords, protecting the rights of cheated home buyers. We've been cheated twice. First,
Lordship, I am for the IRP. Now by the
which went into insolvency. My lords, 1 minute, my lords.
But this was
Three
listed
went
for
into
one
insolvency,
purpose.
which led to this. The allegation by ED is that they've siphoned off money. Now, my lords, Oris was the landowner who signed all the documents, took 196 crores, and now they are trying to deprive us of our flat.
This was
90% of the first phase was constructed. They've taken orders, my lords, from the High Court saying that all flats to be given only to Oris buyers.
I am for the IRP, Lordship.
Where your lordship should order a CBI investigation.
Well, this was only listed for appointing monitoring authority as per the direction of this court.
Oris has also been declared to be a financial creditor.
Can I support them?
The builder is declared to be a financial creditor.
I am a supporting person to supporting to Mr. Vikas Singh Krishna Venugopal for this reason. I'll take only 2 minutes. Please see the impugned order. My lords, the Honorable Supreme Court passed an order of 10th of April to 2026 at page 33. Relevant values at page 34. There was a clear intent of my lords that it will go back to the High Court and they will determine who are the home buyers who fall into this category, and then further proceedings will be taken. Now, well, the impugned order, which so-called impugned, which my learned friends on this side are challenging. Once, let me finish, please.
Yes.
Is a cry of anguish by the learned High Court judge. Just see 2 paras of that. What they have done, my learned friends, both sides of the...
No, but that's absolutely wrong.
We can do away with the literature.
Allow me to finish.
Please
allow
the
me
issue here. Not is completely very.
Allow me to finish.
This is not a question of finishing. You are on the
I don't understand this. I'm in the middle of a sentence. By out-shouting, you can't hide the truth. I am reading what is written. Please turn to para 2, but page 316. Page 316. Yes. Para 5 onwards. The prayer in the miscellaneous application filed there is to
Where are page number?
give the page number.
This is in our IA, Lord. GWA.
Allow me to finish.
47940.
Chief Justice has told you, allow me to finish. 317 of Mr. Vikas Singh's IA. GWA. Give the IA number, please. This is not the way the High Court is to be short-circuited after my Lord's mandate.
Well, that's misreading of the
clear.
application.
Let's read now.
Yes,
Read
yes,
on.
go ahead.
Page 317, relevant part.
Yes.
Relevant part only.
The order of 3rd August you are referring.
That's
That's
correct. That's correct. I'll just read without
Just read
my
this
own
order,
words.
the 4th August order, which I wanted to show you.
The prayer in the miscellaneous application filed before the Supreme Court, a copy of which is appended, reads as under. They give the wrong application to the High Court judge. They give the wrong application to the High Court judge. Defer further adjudication of the present matter as an application seeking clarification of the order of 10th of April, that is my Lord's order, presently pending. 6. Evidently, the prayer extracted above is erroneous, considering it has been made before the Supreme Court of the miscellaneous application as per the copy of the miscellaneous application appended. Then, regardless of the prayer, Mr. Mathur submitted that the court may note the fact that the applicant has passed the said miscellaneous application and may pass appropriate orders. Learned counsel, read 8, para 8. Learned counsel appearing for other parties, including GWA, that is Mr. Vikas Singh, and the Directorate of Enforcement, vociferously opposed the prayer, submitting that quite apart from the fact that the prayer in the copy of the miscellaneous application makes no sense. It's a wrong application filed. Nevertheless, the filing of the application before the Supreme Court is intended to only stall a further proceeding, which is undesirable. Upon this being pointed out, Mr. Mathur, who is for the side who filed the wrong application, gives the correct application, which is today listed. My Lord has got this para 9 application listed today. This is the current one.
Waiting for that.
Correct,
I'll
correct
clarify
one.
this
Yes.
position, Mr. Singhvi.
The different copy of the miscellaneous application is taken on record. Now come to 11. Clearly, the prayer in the application filed before the Supreme Court is to seek a direction that this court may not only defer restitution or disbursement of the proceeds of assets and appoint a former judge of the Supreme Court as monitoring authority. On the other hand, in the present application, prayer is to defer further adjudication. On a combined reading of the prayers in the present application, the miscellaneous application, this court is unable to decipher exactly what the applicant, that is people on my side as well as Kusum Dwivedi. It may be recorded that this bench was in session of the present batch of matters. He has had 14 hearings, the learned judge, and is about to decide this matter who the home buyer after 14 hearings. Under Supreme Court directions, upon change of roster, it is placed back before him. Ignore that. Come to 14. Counsel for ED, GW and other parties have expressed their unreserved stand that this bench must continue hearing the matters. Everybody, except Ms. Kusum Dwivedi and 1 or 2 others. Mr. Kunal Tandon, learned counsel for the promoters of 3C, also states that they want the matters to proceed. As a matter of fact, at the conclusion of today's hearing, Mr. Tanmay Mehta, learned counsel appearing for GWC, that is Mr. Mehta is opposing Mr. Vikas Singh, also says that they are desirous that the matter be heard before this bench. In these circumstances, Mr. Mathur, learned senior counsel, appearing for the applicant, seeks time to take clear and categorical instruction. Now turn
And the next order.
next order.
Next order is very important.
Right next, immediately after this, come to page
Starts at 325.
325.
325. 4th.
Yes,
4th.
that's the next one. At yesterday's hearing in the present batch of matters, Mr. Counsel appearing clear instructions. Leave that one. Let's come to para 3. By way of the present application, Kusum Dwivedi says, defer further adjudication. This is a kind of a game going on, Malus.
It's absolutely.
No, please see after.
That is absolutely wrong. Kindly see.
Para 4. The moment
Kindly see the application which is already on record.
Please don't interrupt me.
Kindly
Allow me to
Para
finish.
8.
Para 4. Before attempting to understand that the applicant wants by way of prayers, it must be observed that a copy of the miscellaneous application was appended. Then, subsequently, learned counsel informed the court that the copy so appended is not a true copy, etc. Leave this.
No, the para 8.
This was on the same
Now
day.
come to para 8. Para 8. Para 8 is most important. This court is constrained to observe in the course of hearings over the last several dates. This court has got the clear sense that there are divergent vested interests at play in the present matters. After my Lord's order, some of whom appear to be interested in derailing or prolonging any effective orders being passed in the present case. Accordingly, this court would view the present with requisite caution. Considering the evidently contradictory pleas taken in the present application, the application filed before the Supreme Court, before proceeding further with the matter, the applicant Kusum Dwivedi is directed to file an affidavit clearly stating her locus standi.
And then 11.
She
Then
pops up as one home buyer.
I am appearing
11,
for.
Let the
very
lead
well.
I must make given a chance to
Sir,
clarify.
after I finish.
Please give me.
Furthermore, it is observed that as recorded in the order of 30th July, Mr. Aman Lekhi was to continue with his submissions. However, Mr. Lekhi was not present on 3rd, nor is he present today, nor is any other counsel present on behalf of COC. Now, Maharaj, how does a judge
carry out
Well,
the
the-
lordship
it's-
mandate of finishing,
Well,
if I don't go and argue.
And your
on my application as a home buyer to say that kindly allow me to clarify this position. Well, as if my lord sees by April's order of my lord, the ED as well as the special court PMLA said that using the provision of section 8 of PMLA, the attached assets of the promoters are to be disbursed to satisfy the claim of the home buyers, which I'm one of the home buyers. Court said that please, initially the judge was appointed and thereafter was withdrawn. Later on, this the application came, my lords, of the order of 10/4/2026 noted that the ED also said, and we also said, please appoint the monitoring authority, some judge of this honorable court. We said, my lord said that the High Court consider and decide them. That's the order on page para 8, which has been done. This is the application I filed. This is the position I have taken before the court that since the assets are there, ED has confirmed this position. Special court has agreed with that position. Please appoint the monitoring authority. The challenge every time from them is on a one pretext or the other that these assets should not be dealt with. All today I'm making an application with instruction, my statement may be recorded, that any monitoring authority may be appointed to deal with it.
Lord, may I just point out?
Today, one application or the other, my lords can see that there is a bloodbath going on the
They are
side.
filing the application.
Nobody is going to
And
get any
are
asset.
not letting the hearing go on.
Look at the situation, my lords. There's a competing interests which are there. They may be vested or not vested. I'm not casting any aspersion against them. Any authority who can look into it, Malatri. All I'm saying, because
No,
if this
judge is
exercise
hearing
it
up
takes,
this matter.
well, 9 hearing it takes, this authority, 9 hearing it takes that today we can't reach a point. Somebody can
Please
appoint.
see all the
That can
hearing
assist the
dates.
court. Look at
Every
this,
date they have delayed. the hearing.
they want nobody else should speak. Nobody else should speak and they should get and prejudice the court on one aspect or the other. All I'm praying before this honorable court, any authority may be appointed that's going to assist the court, Malas, so that the claims can be examined.
Mr. Bulbisi, let the court take a call on it.
Lord, can
Malas,
Require the assistance of a monitoring committee, the court will constitute that committee. If the court requires assistance of some other domain expert, the court will.
Absolutely.
Malas, with so many,
People should.
Look, can I just, I am for the other applicant. Your lordship can say day-to-day hearing, Lord. We are ready to.
all the parties on
other
24
Can I please
consented.
be heard?
We consented on this aspect, Malas. All of us at that point when this order was.
Lord, can I please be heard before them?
My lords, I-
My turn, I am for the applicant, my lord. Mr. Singh and Mr. Venugopal won't allow us to argue.
May
Lord,
I
my
submit-
submission is very simple.
My lord.
That certain assets of the defaulting promoters who admittedly siphoned off the money have been seized by the enforcement director. Who that money has to come back to is a different question which is under adjudication. Why should those assets not be monetized in a pool for all home buyers? Mr. Singh's client, Mr. Venugopal's client have been obstructing the appointment of.
No, there is no obstructing at all.
Absolutely not fair.
I think the ED will answer this question better.
Lord, I'll explain why.
Yes.
I'll explain why. My lord, every time the matter comes up before the High Court, after your lordship's order is shown and the ED suggestion is made, Mr. Singh's and Mr. Venugopal's clients say we are opposing this for the.
No, never. Just read the order.
Precisely, that's the.
Just allow me, my lord. They are opposing restitution.
Matter, if they are opposing, it is ultimately for the judge to take a call.
Decide.
Lord, that's not, just let me explain. My lord, what they are opposing.
they will
is
eventually-
restitution. What
Every
we want,
adjournment, if you come here with an SLP, how will the case get over?
Lord,
It
Lord,
is listed on 13th
Lord, that is
August.
our
13th August.
Adjournments.
Lord,
You go and argue on
our-
your case, all your problems will be sorted.
Lord, our trepidation is that they are not allowing the hearing to conclude one way or the other.
Court not controlled. This is also, it's a high court.
Lord, I agree, but our trepidation is why should money siphoned off?
File an application here because somebody moved an application. What is?
Well, Lord,
It's
our-
No,
only
they
for-
are only
was-
moving application.
Our-
Lord, they are only moving application. They are seeking adjournment and now coming here and saying that the matter is
I
not
asked
going
myself
on.
one question.
Never
Yeah,
ever-
just read the entire order sheet. I can read the all entire order.
Problem if cheated money is put in a pool under the supervision
But
of.
that's
the Supreme
precisely
Court
the
judge.
My lords, just see.
We have
it.
no difficulty with that, but that is only a purpose to derail that proceeding.
That cannot short circuit the
Lord,
proceeding.
I have a suggestion.
I think Mr. Raju can answer that point. Lord, ED proceedings are, Mr. Raju is also having a problem.
May I only,
Mr. Sadhu, do you want to say something additional?
Yes, my lord, I want to say this, my lords. First, my lord, direction should be given to the learned judge in the High Court to decide the matter as soon as possible, preferably within a time-bound ban, 1 week or so. One. Secondly, my lord, as far as ED is concerned, ED is not concerned with the properties of the company. These are properties of the promoter, which is outside the purview of the resolution professional. I don't want the IRB to intervene, my lord. I have doubts about the integrity.
I'm here.
I'm
here.
To monitor the entire thing, including adjudicating who are the genuine home buyers. If the IRB steps in, it is going to be a chaos and it is unwarranted persons and persons who don't deserve will be given the money which I don't want. I want a retired judge of this honorable
May-
court
may-
monitor who are the genuine home buyers.
Genuine
Because
home buyers, only that question.
a large number of home buyers are propped up by the builder, my lords, which I don't
That's
want.
whom they are
That's the-
representing.
And if identification is a problem, therefore a retired judge of this honorable court must decide who is to get the money.
The home buyer.
And they are not allowing the high court to proceed, my lord. Every day there's a ruckus in the court.
Let me just bear with me for a minute because Mr. Raju has raised a point on the IRP. I just need to 1 minute. No, let me address the court, please. Lordship, it's as follows. This IRP, for whom I'm standing, was appointed by an order of the NCLT and the direction was verify the claims. The problem with this particular case is that it was a collusive proceeding started CIRP by the ex-promoters who took the money, siphoned it off and then disappeared. And then somebody propped up and immediately admitted the claim. At that point, there were 2 IRPs changed. This is the third one. The third one came, he was directed, please do a verification of claims. 3 reports were submitted. That challenge to the verification was rejected by the NCLAT.
No.
1 minute. I am addressing the court. This is not fair. I am addressing. No, I will. Lordship, I am not
He has
saying anything
accepted the
incorrect.
builder as
I'm
not a-
sorry, Lordship. I will not say anything incorrect. I owe it to the court. I don't owe it to any of the.
No, you are being dishonest.
No, I'm sorry. I'm not dishonest, Mr. Singh, and this is not fair.
He should act.
This is no. The challenge to the verification is an order of the NCLAT which clearly rejects it. Now, there are 2 home buyers here. There is a GWA, which is an association, Greenopolis Welfare Association. There is a GWC, which is a Greenopolis Welfare Confederation. Now, in between, just bear this in mind, these 2 are fighting with each other. To cut a long story short, there are 3 status reports, including the verification with no cooperation from the ex-promoters. Whatever was there was placed before the court. Now, thereafter, the matter came before this honorable court. This honorable court, in continuation of the CIRP proceedings, directed the NCLT to look at the complaints on the IRP. That also has been adjudicated.
No.
Yes, it has been. There is an order. Lordship,
Wrong statements are being
Lordship, it's an
Sorry,
order
I'm
of
really
December
sorry to say.
2024. I'm
Please
sorry,
direct the
Mr.
High
Singh
Court
is
to
not
decide.
instructed. Note of the ED, which says, just last 3 sentences, press note of the ED comes out for restitution of assets. The IRP is before this court says, yes, I'm giving my undertaking as per the press note that the restitution should be done. The issue is restitution. The challenge here is that when the IRP files for restitution, one set of home buyers files a contempt against me. When he doesn't move on restitution, the other set of home buyers do it. These are competing interests. The court has to
Here the
decide.
IRP is
Lordship
not
said for a
colluding with
judge,
Forest
perhaps
Conservancy.
that's the best way.
Because this IRP is in contempt, there's a judicial order
Right.
saying that he's biased.
He's colluding with the builder.
He's colluding with the builder.
And
The
Lordship,
NCLT has
the
found,
three
my lord, the
member company
NCLT
report
has
against-
found that he is colluding with the builder. He's made the builder, my lord, as a COC member. Builder, 80%. 80% is always according to him. And he's trying to defend the home buyers. He says, and all the home buyers, not the genuine home buyers of 13, have been rejected by the
Contempt
IRP.
notices have been issued against him.
That ED's prayer.
It's correct, Lord. It's correct, yes. That should be done.
That's about the.
Let the home
Once
buyers
the High
determine
Court
by
judgment
a retired judge.
GWA is a front of the
Who is
promoters.
the genuine home buyer? Let it be decided by a Supreme Court judge. We have no difficulty.
That's all we are saying.
Not everybody.
With the what ED is saying.
Just one request. Direct Justice Bambani or request Justice Bambani to hear this matter day to day at 3:30 p.m. and finish the entire batch, my lords. That's our
That will be
request.
best, yes. Even
Yes,
That's what I said.
and in the meantime, these claims can be verified by.
And they can.
These applications have been moved for clarification stroke modification of our order dated 10th April 2026. By that order, we decline to express any opinion on merits of the allegations or cross allegations made by 2 sets of home buyers and thought it appropriate to request the learned judge of the High Court to take up the case for final disposal. The parties were directed to extend full cooperation to the learned judge. Next, right, we mentioned that the matter was pending with Justice Anup Jairam Bambani of the Delhi High Court. Various orders passed by the learned judge revealed that despite his efforts being and despite his,
Clear direction of the Lord.
despite the
Honest efforts
extraneous
made by-
despite the best efforts made by him for early disposal of the case, comma, moving of one or the other application by the contesting parties is creating impediment before the learned judge. Also, in such circumstances, comma, we are constrained to issue additional directions. In the particular circumstances, comma, while disposing of these applications, comma, we are constrained to issue the following additional directions. One, we request Justice Anup Jairam Bhamani to continue with the matter on day-to-day basis and make an endeavor to decide it finally at the earliest. Two, learned senior counsel, stroke counsel for the parties are requested to extend full cooperation to the learned judge towards final disposal of the matter. Three, the Justice Anup Jairam Bhamani will continue with the matter even if there is a change in the roster. Even if there is a change in roster. Next paragraph. The High Court may consider the prayer made by the Enforcement Directorate of Enforcement and other competing parties, reconstitution of a committee headed by a former judge of this court, and an appropriate decision in this regard may be taken.
To monitor.
No, Lord, with regard to restitution.
Restitution.
About the scope?
No.
Left open.
For monetization.
There will.
The court will decide, Lordship. The court will decide.
They don't want the assets of the promoters to be liquidated.
This is
But
for.
they are actually fronts for the promoters. Very well. That is.
Yes.
That will be sufficient.
My lords may say preferably within a week, my lord, let dispose of the petitions.
No further application
Yes.
by the parties to delay the ongoing proceedings. before the
Very
court.
deeply obliged.
Most deeply obliged.
दोस्तों ये था ग्रीनोपोलिस मामले में माननीय सुप्रीम कोर्ट की सुनवाई का पूरा अपडेट। हजारों घर खरीदारों के हक की इस लड़ाई में आगे क्या होगा और क्या दिल्ली हाई कोर्ट में अब इस केस का जल्द निपटारा हो पाएगा? आप भी अपनी कीमती राय नीचे कमेंट्स बॉक्स में जरूर साझा करें। जय हिंद दोस्तों।